That's early, but the next matter to come before the court is Gasper versus Bank of America, and both counsel present. Thank you. Both parties will have 15 minutes in which to present your case. If you're the appellant and you wish to retain some of that time, let me know when you come up to the podium. I'm keeping track of the clock. I'll keep you apprised of the passage of time. We have read your briefs and we're ready to proceed when you are.
I'm Jeff Bramley, representing plaintiff appellant the Gasper.
Brooke Batista, representing the FLE Bank of America, N.A.
Thank you. You may proceed.
May it please the court, counsel, could I reserve 5 minutes for rebuttal? Your Honor, there is no testimony, transcript testimony, because it was no testimony in this case. It's all procedural. So I would like to run through the relevant procedures because they all tie in with my assignments of error. My first assignment of error is that the trial court erred in granting appellee's motion to vacate its default judgment against appellee for failure to perfect service of process on appellee. So my issue that I framed was service of process effective upon incorporation at an address reasonably anticipated to reach the intended recipient, provided the certified mail receipt is signed and returned, even if it's not delivered to the defendant or person authorized to receive service process. So in this case, it didn't come back unclaimed. It was signed by somebody at the defendant's place of business as far as we knew. So I hope I'm not being too boring, but this case started off with my client's husband's passing on June 25th, 2014. He died owning an undivided 1/2 interest in their marital residence. So it wasn't survivorship, and probate will was filed for probate, and in the will he bequeathed the real estate to his wife. Back in 2010, Robert Gasper, the deceased husband, had signed a mortgage with Bank of America. He did not ask his wife to sign. She did sign the mortgage deed waiving her dollar rates. So the probate court appointed my client, Mrs. Gasper, as the executor. After the case was filed in probate court on October 24, 2014, Bank of America filed its statement of claim, asserting its mortgage note and the deed listing its address at 1755 Tapple Canyon Road, Simi Valley, California. And that address was provided by Bank of America, and that's the address that Mrs. Gasper and myself used in all the following proceedings. It's also the address that the court used. The probate court also used that address. On December 4th, 2014, Mrs. Gasper, as executor, filed a rejection of the Bank of America mortgage claim. Bank of America filed no filed no objection to the rejection. On March 4th of 15, the executor filed her application for family allowance and representation of insolvency of the estate. Bank of America's claim was listed as a Class 10 claim along with another mortgage to Citibank. The estate, the probate court notified Bank of America at that Simi Valley address of the hearing regarding the executor's motions, and the court found that In fact, the estate was insolvent, and it disallowed the Class 10 claims of which Bank of America and Citibank were part of. Found the surviving spouse was entitled to the family allowance and ordered that the real estate be transferred to her in lieu of the of her taking the $40,000 family allowance. Bank of America was served with a copy of the court order at the Simi Valley address, which they had provided to the court. Bank of America filed no objection or appeal. Subsequently, on June 4th, 15, probate court granted a certificate of transfer to Mrs. Gasper, transferring the decedent's interest in the residence to her. Subsequent to that, I sent a letter, certified letter, to both Bank of America and Citibank on August 25th, 2015, demanding that both release their mortgage, and including a copy of the probate court's order. And there was no response from Bank of America. Citibank did respond and subsequently reached an agreement with them, and they released the mortgage, their mortgage. The certified mail went to the 1755 Tapple Canyon Road, Simi Valley, California, and it was signed by Gennaro Servasio, August 28, 15. Now, this is the person that Bank of America says was not authorized to receive service process by Bank of America. On September 15, 2015, filed the title quiet action against Bank of America. And again, the clerk sent out the complaint summons to the Simi Valley address to Bank of America. It was again signed by Gennaro Servasio on September 2017. No response from Bank of America to the quiet title action. On January 5th, 2016, the trial court granted default judgment declaring the Bank of America mortgage null and void. Clerk sent a copy of that to the Simi Valley address. No appeal was filed by Bank of America. Apparently Bank of America assigned its mortgage to Fannie Mae on October 2nd, 2015. This was unknown to the appellant counsel. They did not send any notice to Mrs. Gasper about this assignment. So on July 20th, 2016, Fannie Mae files a foreclosure against Mrs. Gasper in Common Pleas Court, Judge Collier's court, and on the Bank of America note and mortgage, which had been declared null and void by Judge Kimbler's court in the quiet title action. Of course, we filed an answer asserting the judgment entry of the court from January of 2016, and that was also filed with the recorder's office, declaring the Bank of America mortgage null and void. Finally, I filed a motion for summary judgment on the basis of the null and void judgment entry from Judge Kimbler. And the day before the motion briefs were due, Bank of America dismissed its foreclosure in Judge Collier's court. On May 16, 2017, Bank of America files its relief from judgment motion in Judge Kimbler's court. And they also amended the entry amended the motion to add their allegation that service was not completed. Originally started as a 60B5 motion. So the court, Judge Kimbler's court, on, let's see, No, I'm sorry, the motion for relief from judgment was filed on March 17th, 2017. And then the trial court granted the motion for relief based on the jurisdiction issue, service of process issue, on May 16th, 2017.
Counsel, that May 16th, 2017 order by the trial court, was that a final appealable order?
I don't believe so, Your Honor, because the case was still pending.
What was pending?
The case was reactivated then because a default judgment had been granted, so it was placed back on the court's regular docket.
Isn't the default judgment granted in a different court?
No. No, it was Judge Kimber's case from the get-go on a quiet title action.
Well, if you had Citibank and you had Bank of America, Citibank is out of it at this point.
Right. So it was just Bank of America. And Judge Kimber heard the arguments. She granted the default judgment, then when the motion for relief from judgment was filed.
And when the motion for relief from judgment was granted, it is your position that that was not final, something that you could have appealed?
No, I don't believe I could have. It wasn't, it didn't state that in the entry. And as I said, the case was back on the court's regular docket at that point.
Okay.
Okay. So on July 18th, and it's back on the court's regular docket, the trial court's regular docket, Bank of America, who has not yet even filed an answer to the quiet title action, files a motion to dismiss. And at that time, they set forth their alleged assignment of the mortgage to Fannie Mae and say, we don't have any interest in this case. You need to go after Fannie Mae. They have the assignment of the mortgage.
Counsel, procedurally, you can't file a motion to dismiss after you file your answer. I mean,
They filed it before, yes, yes. And I'm just pointing that out because in my second argument on appeal is that we weren't granted, the court denied, we believe it's abuse of discretion for the court to not grant us a motion to amend because once they advise us that someone else held the mortgage in a quiet title action, we have to add that person as a new party. And that's what my motion said. Okay, they say they passed the buck on to Fannie Mae. Well, we want Fannie Mae then as a party. They could have filed a joinder of Fannie Mae, but they chose to just file it as a motion to dismiss.
What about the alternative, I guess, the alternative was that the relief sought couldn't be granted anyway. I mean, when you filed the motion to amend the complaint, was the amended complaint with that motion?
Yes.
Okay. And the only difference between the original complaint and the amended complaint was the addition of the Fannie Mae?
Well,
And
there was some change in the verbiage because of the assignment.
Sure, sure. But, okay.
Yeah. So, the court, let me make sure I got this right. On December 4th, 2017, the court denied both appellant's motion to amend and, well, denied plaintiff's motion to amend and granted Bank of America's motion to dismiss, which stating that my complaint did not set forth the cause of action, basically. And my argument is that the court improperly weighed the allegations that it was up for the trier of fact to decide whether the probate court's order said what appellant said they said. So the court basically just, no answer had even been filed yet. One of the arguments that Bank of America made was that appellant waited, over a year to amend its complaint. Well, all during that year, it was actually about 14 months before since the default judgment was granted, before Bank of America filed this motion for relief. Why would someone that had a judgment granted in their favor amend their complaint? They just couldn't do it. I mean, we had a judgment, and we had a judgment up until when the court ruled that they granted the motion for relief that Bank of America sought. Then the clock started ticking, and then once they said they had to sign the mortgage, then within a month I filed the motion to amend the complaint adding Fannie Mae. I am aware of the recent case that this court ruled on in Runyon versus Hawley, and I would like to address that. In all the cases where service was found to not have been made, even in Runyon, where it was sent by certified mail to the agent's, the corporate's agent's address, they all came back, the certified mail receipts came back unclaimed. And the distinction with this case is that that did not happen. The certified mail came back by someone who signed for it. And on those requirements, yes?
I forgot to stop you, we have 5 minutes left, so we're out of time. I'll give you another minute or two for a vote, but I
Okay.
stopped you, I'm sorry.
Well, and that's you know, the distinction that I feel there is between Runyon and this case. And in fact, if you look at the you know, Swinehart was reasonably calculated to get to the defendant, what more could Mrs. Gasper have done here? The Bank of America themselves said, this is our address, okay? And when I come back, I'll talk about whether a hearing should have been held by the court, and whether there was the irrebuttable presumption part of it. Thank you.
Apologize.
Good morning, Your Honor. My name is Brooke Batista, and as I said earlier, I represent the FLE Bank of America NA, which hopefully, for convenience sake, I will refer to as BANA, or sometimes Bank of America, I guess. It just comes out a little easier. I'm going to spare the court a long dissertation about the facts. We've set those forth in our brief. I'd like to just quickly start off by addressing the question posed by Mr. Bramley, which is what more could Mrs. Gasper have done to serve BANA at its proper address? Quick and easy answer, look at its statutory agent. It has a registered statutory agent, easily found on the Ohio Secretary of State's website for service of process. That's who's designated to receive service of process for BANA. Alternatively, the burden shifts to Mrs. Gasper to find the correct address. If she's not going to use the statutory agent, she has to find the usual place of business for BANA. While at one point in time, the Tapo Canyon address was BANA's usual place of business, and at the time that the probate court action was initiated, it was its usual place of business. However, 30 days before the quiet title action was filed, BANA had moved from that location. It was no longer its usual place of business. And under the civil rules for service, when you're going to serve not the statutory agent, but at a usual place of business, you have to find the usual place of business. That's the plaintiff's burden. The fact that they used what they thought was the usual place of business isn't good enough. The fact that a security guard in that building where BANA used to have its offices signed for that isn't good enough. He wasn't their registered agent. He wasn't an officer. He wasn't an employee. He wasn't authorized to accept service on behalf of BANA. And the fact that he signed for it doesn't change that. BANA came forward shortly after becoming aware of the default judgment through that prior foreclosure action that was initiated by Fannie Mae, came into the quiet title action, moved to vacate the default judgment, and ultimately amended that to say, look, we have an affidavit from our employee who establishes that, number one, at the time of service, the summons and complaint and a quiet title action, we didn't have a usual place of business at this Table Canyon address. Number two, Gennaro Cervasio, who signed for that certified mail, wasn't authorized to do so. And more importantly, number three, we never received notice. We didn't receive notice of the summons and complaint. We didn't receive notice of the default judgment, the motion for default judgment, and we didn't receive notice of the final judgment. So with that evidence before the trial court, any sort of presumption that service was proper through certified mail and by following the rules of civil procedure under 4.1A1 are overcome with that evidence. Mrs. Gasper at no time offered any contrary evidence to the affidavit of Jennifer Black that was submitted by Anna, demonstrating that those items, that they were not served, that they didn't have their usual place of business there. So for the trial court to not accept that unrebutted evidence demonstrating that service was not proper would be an irreversible error on its part. It was obligated, and I think the 9th District cases are pretty solid in terms of finding that when an unrebutted affidavit is set forth demonstrating that service was not perfected, that the court is required to reverse that default judgment because it lacked jurisdiction. It lacked personal jurisdiction over the defendant, and any judgment rendered after that was void. The trial court properly went through that analysis, reviewed the affidavit with no evidence to the contrary, properly found that the motion for relief from judgment was proper and vacated the default judgment. So that addresses the first assignment of error raised by Mrs. Gasper. I think it's appropriate to address the third assignment of error next, because Mrs. Gasper raises an issue with the trial court granting Banna's motion to dismiss, suggesting that it was improper. And of course, the review on this is a de novo review, but I think it's important to note that Mrs. Gasper's entire complaint was based on a misreading of the probate court's decision. Her suggestion in her complaint was that the trial court should declare the Banna's mortgage null and void, release it from the records of the county recorder, and quiet title in favor of Mrs. Gasper, because that's what the probate court's decision dictated. And that's simply not the case. Not only does the probate court's decision never say anything like that, the probate court doesn't have the authority to vacate or void a mortgage. The probate court's authority is to address the claims presented before it. If there are assets to be divided, divide those assets. But that's with respect to Bank of America's note. So Bank of America filed a claim saying, hey, we're owed money because Mr. Gasper took out a loan for $158,000, whatever the amount was, and both Mr. and Mrs. Gasper signed a mortgage pledging their property as security for that loan. Mr. Gasper passed away, and so his undivided 1/2 interest becomes a part of the estate in front of the probate court. Bank of America, or Banna, makes a claim saying we're owed money under this loan. Mrs. Gasper files the appropriate filings to suggest that the estate is insolvent and it can't pay on that note. The court finds that that's the case, and then says the property can't reasonably be sold to pay off the liens on it, so we're doing nothing with those claims for money to be paid. That doesn't address the mortgage. The mortgage is separate and apart from the note and what's owed on the note in terms of the probate court's decision. The probate court at no point said, I'm giving her, Mrs. Gasper, the property free and clear of all liens. It didn't have the authority to do so. At no point did it say, I'm wiping out the mortgage of Bank of America. It simply said, the property can't be sold for the enough to pay off the debts of the estate. Therefore, Mrs. Gasper can take the property. But as with any other heir or decedent, she takes it subject to any liens that are on it. All property that passes from someone who has passed away and goes to heirs or devisees takes the lien with them. It doesn't wipe out the lien just because it transfers from one person to another. And stepping back even further from that, Mrs. Gasper herself mortgaged her undivided 1/2 interest. So even under some bizarre theory that the probate court had the authority to wipe out Mr. Gasper's interest, or Mr. Gasper's lien on the property through Mr. Gasper's undivided 1/2 interest, it had no authority to do anything with Mrs. Gasper's interest, which she also pledged as security for this note. Her interest was not subject to the jurisdiction of the probate court and remained, when the property was transferred to her, subject to all the liens. I think there are two different statutory provisions that are relevant to this particular assignment of error, both of which dictate that mortgage liens continue to run with the property regardless of how they transfer upon death. So I would direct the court to 2113.52 and 2117.29, both of which dictate that a probate court does not have the authority to wipe out mortgage liens, and that those liens remain effective as to anyone who takes the property post-death, with the exception of if they wanted to pay off those liens. Obviously, they could pay them off and take the property free and clear. That's not what happened here. And then addressing the second assignment of error, well, let me take a step back. I'd like to point out that the trial court's decision in granting Banna's motion to dismiss was reasonable, and there was an effort to suggest that the trial court reviewed it at a level that should have been reviewed by a trier of fact, and it went beyond what it could do in terms of assuming all facts to be true in the complaint. I don't think that's the case here. I think the trial court's order very clearly said no one could ever possibly read the probate court's decision the way Mrs. Gasper's complaint suggests that it should be read, and there's no statutory provision that would ever allow a probate court to do what she was suggesting. So while reasonable inferences regarding the facts are appropriate by the trial court in reviewing a motion to dismiss, unreasonable conclusions are not, and I think that that's what the court did here, was to say there's absolutely no rational basis why any court could read this, or any trier of fact could read this probate court's decision and come to the conclusion that Mrs. Gasper is attempting to come to. Which then brings us to the second assignment of error, which is Mrs. Gasper takes issue with the fact that she wasn't permitted to amend her complaint. First and foremost, I think Banna properly argued that any attempt to amend the complaint after it had filed a motion to dismiss was both untimely and prejudicial to Banna, and I think the Ninth District is pretty clear that any sort of attempt to amend a complaint after a motion to dismiss has been filed raises a specter of prejudice. So while the policy for allowing plaintiffs leave to amend their complaints freely is typically in place, it's not an absolute right, and that liberal policy only falls into place absent any sort of untimeliness or undue prejudice on the part of that would result on the part of the defendants. So I think that the trial court was right in finding, number one, it was untimely because they attempted to amend the complaint at least 5 months after they knew that Fannie Mae had been assigned the mortgage. So what happens is they filed their complaint with the quiet title complaints. About 16 days later, Bank of America transfers the mortgage to Fannie Mae by assignment of mortgage. Mr. Bramley noted that Fannie Mae at some point filed a foreclosure action, and that was the first time that Bank of America becomes aware that there's this default judgment out there. Fannie Mae doesn't proceed with that foreclosure because someone's got to deal with this default judgment that seemingly is wiping out the mortgage. Bank of America then interjects, or files its motion for relief from judgment in the quiet title action, and proceeds from that point. But as early as, well, October of 2016, there's record notice of the assignment of mortgage because that's when it was reported. As early as, I think, March of 2017, when the foreclosure action was filed, and Mr. Bramley interjected and said, wait, Fannie Mae, you can't do this, we've wiped out the mortgage. They knew about the assignment of mortgage. When BANA filed its motion to dismiss, motion for relief from judgment in the quiet title action, it raised the issue that it no longer had any interest in the property because of the assignment of mortgage. And yet, it was 5 months later before there was a motion to amend the complaint. The motion to amend the complaint didn't change any of the facts other than alleging, okay, maybe Fannie Mae has an interest in this property too, and we want to add them. So it's untimely because it's months, maybe years after they had at least record notice of the assignment to Fannie Mae. It's prejudicial because it's post-motion to dismiss when they're attempting to massage the facts the way they want and to respond to BANA's motion to dismiss. Excuse me. And the trial court also found, as BANA argued, that any sort of attempt to add Fannie Mae without changing the allegations as they were in the original complaint was futile because no court could ever find that the probate court's decision did what Mrs. Gasper alleged it to do. So I think BANA's position is that obviously the trial court properly granted its motion for relief from judgment, granted its motion to dismiss, and denied Mrs. Gasper's motion to amend the complaint because at the heart of all of this, the probate court's decision doesn't do what Mrs. Gasper thinks it does. And there's no rational reading of it of that decision that could come to that conclusion, and the trial court probably found that. Thank you.
Thank you. Mr. Bramley, I'll give you 2 minutes.
2 minutes, okay, thank you. I'll try to be quick. Again, I can't amend a complaint where a judgment's been granted within 3 months of the court's ruling, relief, and putting the case back on the general docket. We filed a motion to amend. Regarding the service of process, we've cited all these cases, and as I said, our case is different in that the process, the service certified mail was not returned on claim, it was signed for. And under the Swinehart and the cases that follow the Supreme Court, we listed them in here, it's reasonably anticipated to get to the defendant, then it's good service. The defendant provided the address. We used that address. It provided it to the court. What could be better than that?
Isn't it a rebuttable presumption of good service?
Well, I understand that from Runyon. What my position would be, and it's argued in some of these cases, is when it's signed by someone, then it is put at issue. And that it's the court, and I know I'm in an area here that may not be totally in my favor, but the court should have held a hearing. Now, Bank of America, in their amended motion, requested a hearing. And I know what you're going to say. Well, did you request a hearing? Well, I didn't request a hearing. Mrs. Gasper requested a hearing because we thought that the service was proper. And if the court had granted a hearing, we could have presented. Bank of America would have had to bring in somebody to say that they never got it, which is what the affidavit said. But I guess we would have figured out some way to get Mr. Servano into the court, either through online deposition or fly him in here. It would be some expense, but he's the one that signed it, and I bet you he would have said he'd been accepting these service of processes for years. And Bank of America, if they move their address down the street, are they gonna, what happens to people sending in their deposits or their accounts? They're a big company. I mean, they're the second largest bank in the country. Why wouldn't they make provisions to have these documents and customers' deposits forwarded to them? It seems highly unlikely that they would not have done that. So I don't think that they deserve any benefit of the doubt here. They created the problem that exists here in this case. And I would ask that the court reverse the trial court's ruling on the jurisdiction issue on the motion for relief and reinstate the judgment. In the alternative, I would ask the court to order a hearing on that issue and require Bank of America to prove that Servano or whatever never had authority, and we could go forward from there and get to the bottom of the issue.
Thank you both for your presentations today. The court will take the matter under advisement, issue a written decision which will be posted to our website as well as that of Supreme Court, and mail to both parties. Again, thank you both for the presentations today.